Hi there. It is Thursday, December 5th, 2024, and this is Alan Zundell welcoming you to Political Dharma. On today's show, I'm going to take a more in-depth look at that federal lawsuit in which three minor parties are complaining that California's open primary top two electoral method violates their constitutional rights. Now, I touched on this in a previous episode, I think the one just before this, actually, but I wanted to look at it more closely because I think it touches on several themes of this show and is going to have wider implications. For one thing, voters across the country are feeling more or less politically homeless because they are not happy with the two major parties and don't feel like they have much of an alternative beyond that, especially voters who have not affiliated with the major parties. There's a lot of so-called independent or non-affiliated voters who do not have any role in the primaries in a number of states in order to determine who gets on the general election ballot. For another thing, we would like to see more competitive elections, that the minor party and independent candidates for different offices do not have um, artificial barriers keeping them from being as competitive as possible so that people would feel like they are choices if they do find those parties or candidates attractive. And then also, there have been multiple electoral reform efforts going on across the country, and we had like a half dozen of them just in this past November, most of them using some combination of so-called open primaries and then ranked choice voting in the general election, and they all failed. But these groups, these movements are just going to regroup and then try again, I'm sure, in future elections. They will also be watching this case because it is going to help determine the shape of the open primary movement in particular and determine what kind of reforms going forward will pass not only voter approval, but constitutional muster. And I think this case here in California has a good chance of going all the way to the U.S. Supreme Court and will set the parameters for what kind of voting reform efforts are going to be available going into the future from here. All right, so let me review once again what that was all about. Oops, here to this one. Okay, here's the face page of that complaint. So we see that three minor political parties, or as I prefer to call them, alternative political parties, the Peace and Freedom Party, the Libertarian Party of California, and the Green Party of California, as well as a number of their former candidates and voters who would like to have voted for those candidates or parties, have brought a lawsuit saying that the California's open primary top two system violates their constitutional rights. Among other complaints, they said that the primary in California is held way too early for minor parties or independent candidates to actually gear up for an election, that independents don't have time to put together a campaign and decide whether to run, and that minor parties don't have the time to decide which of their possible candidates for nomination they are going to agree on. They also complain that whenever there's more than one major party candidate on the primary ballot, the minor parties or independent candidates can't get on the general election ballot, thus depriving them of the opportunity to even have people vote for them. So that makes it limits the ability of these parties to grow and obtain office sometime in the future, and also makes it hard for them to retain their status as qualified parties in the state of California, which gives them the privilege of having their name get onto the labels of candidates. When candidates are on the ballots, they can label themselves with qualified party names. And in general, it violates the rights of these parties and these voters and candidates to try to further their own political beliefs and to have a meaningful vote in the general election, violates their freedom of expression, their freedom of association, freedom to be candidates who voters can actually elect. And all these rights are contained under the First and 14th Amendments to the U.S. Constitution. The First Amendment, of course, guarantees rights like freedom of expression, freedom of association. And then in the 14th Amendment, we're all guaranteed equal rights under the law. And most of the rights in the Bill of the Law, excuse me again, most of the rights enumerated in the First Amendment to the Constitution are held in the 14th Amendment to also apply against state governments and not just the national government or federal government. All right, so I did want to clarify one thing. Well, in my previous episode, I did note, and this is from Ballot Access News, I got this information. You here see the first couple paragraphs on your screen if you're watching the video. You see the first couple of paragraphs of their story on it, Ballot Access News by Richard Winger. And it says at the bottom there, where I've highlighted it, there's only one exception to that statement, that when there's two major parties, more than one major party candidate in the primary, nobody else can get on the general election ballot. They said there's only one exception. In 2024, that is this November, the American Independent Party candidate for the Assembly qualified for the general election ballot. So there has been at least this one exception, but the mistake I made in trying to identify this, I glanced over the Assembly races for California and identified State Assembly District 9. But as you can see on your screen, if you're watching this, the Democrats in that race were not on the ballot. They were write-in candidates. So it was not that race. The only ones on the primary ballot was one major party candidate, a Republican, and then an American Independent Party candidate as well. So I looked further and discovered that it was twice Assembly 9, actually Assembly 18, where they had a Democrat who won the election ultimately, and two Republicans, as well as an American Independent Party candidate. And even though the Democrat got like 85% of the vote in the primary, still the American Independent Party got more votes than either of the Republicans and was able to appear on the general election ballot. So I wanted to make that correction of my error in the previous episode, because you know by now that I always try to correct my errors. I hope you believe me when I say that anyway. I have tried to do that. So what is this open primary top two system all about? Let's review the specifics of it. The open primary concept, what's now called an open primary, it used to have a different meaning, but now that there's a movement for this type of primary, it's going by a different name. In the past, this was called a jungle primary or a blanket primary. Essentially, every candidate from every party runs all together in one primary, and the voters can choose any one of those candidates to vote for. That means that even if there's several Democrats who would like the Democratic Party's nomination, that doesn't matter as far as getting in the primary or getting on the general election ballot. What matters is that you have to compete against all the Democrats, all the Republicans, all the other candidates in the primary. And then if you get at least more votes than the third, fourth, fifth place winners, you'll be on the general election ballot. So jungle primary in the primary, what they call an open primary. And then the two candidates who got the highest number of votes advance to the general election. That's why they call it the top two. Now, both California and Washington have this method instated, as well as a few other states. Let's take a look at where this is actually practiced and some of the differentiations between them. All right, so we have a map here that I pulled from Ballotpedia, and it shows in green the 5 states where there's some form of a top two system going on. Now, down there by the Gulf of Mexico, they show Louisiana, and I don't think that should be included there because actually they do not have a open primary. All the candidates from all the parties run in the general election. So there's no barring of any candidate from the general election ballot. But if no candidate gets more than 50% of the votes, there will be a runoff election scheduled about 6 weeks later in order to determine who is going to be the ultimate winner in that election. So in Louisiana, it's not a primary that has all the candidates running together. It's actually the general election, and that's long been held to be fine by the courts, I think. Up there in Nebraska, in the middle of the country, only the state legislature is subject to this, and it is distinct from California and Washington in that it is a nonpartisan election, meaning that the candidates do not have party labels by their names. And in fact, they are not elected in the general election with party names either. So it's a nonpartisan legislature, a one-house legislature, the only one in the country. And so Nebraska is a little unique. they have all the candidates run in the primary, but it's a nonpartisan primary. And then the top two go to the general election ballot. And then finally, we have Washington and California, which have this open primary system, followed by the top two going to the general election. There are a few differences between them. For one thing, Washington's was adopted early in 2008, and then California followed in 2010. Um, in Washington, each of the candidates can choose any label for themselves to be put on the ballot. They have 16 characters, meaning, numbers, letters, and blank spaces, in order to define how they want to be represented. So a candidate could choose to say they're of the Democratic Party, of the Republican Party, of the Green Party, of the Libertarian Party, or make up a name like the Alan Fallon Big Fat Palin Party, but that would be too many characters, so they couldn't use that. Alan Zundel Party, let's say it that way, or the Political Dharma Party. How about that? So they can make up whatever they want. Whereas in California, a party has to be a qualified party in order to allow a candidate to use that label on the ballot. So as long as your party has qualified, which means they've either got a certain number of registered voters or a certain percentage of the vote in a previous statewide election, then that party is qualified. And as a candidate, you can choose to use that label. Now, in neither case do the parties, the actual political parties, have a say in who gets to use that label. It's just that Washington is a little more loosey-goosey about making up things to put on the ballot there. Finally, in Alaska in 2020, they also instituted this open primary system where all the candidates run together in from every party, and you get to choose one to vote for. And in this case, though, it's not a top two system, so it's a little different than California, actually a lot different than California and Washington in that respect. They have a top four. The four top vote getting candidates go to the general election and are then elected by a process of ranked choice voting. Now, this concept of both the ranked choice voting and the open primary, as I said, did not do that well in the general election in November because there were a number of initiatives. So their future is in doubt, but I'm sure in some form they will be back. Now, I want to emphasize that in none of these states does the open primary concept apply to presidential candidates for various reasons. There have been efforts in California to object to the fact that the presidential election does not use the open primary because, according to the language of the state constitution and the laws, it seems like it should. But that I'm not going to go into that argument because it's a little bit off track. What the courts have held in the past is that the national political parties have their own process for determining primaries, and then the states have to some extent, accommodate that. Otherwise, it's just that the president is an exceptional case because it's the same candidate across the country, and all the states have to follow certain parameters, not be too different from each other. All right, so let's look at California and Washington in particular, because these are the states where there have been previous court cases that have made some determinations about this open primary top two system. Now, I'm going to start with some cases about a previous system where it was not really top two, but they did have open primaries. In 1935, the state of Washington adopted an open primary, that is, one in which all the candidates from every party ran together. But instead of having a top two go to the general election, they said that the candidate of each party who got the most votes in the primary becomes the party nominee in the general election. Let me walk you through that. That means they hold this open primary, and then all the candidates from a single party, that is, say, all the candidates from the Democratic Party, whichever of them got the most votes in that open primary, whoever the voters were, they didn't have to be Democrats, then becomes the Democratic Party's nominee in the general election. Same with the Republican Party and presumably some of the other parties as well. So this is different. And in 1996, California adopted that Washington system. But in 2000, there was a case called the California Democratic Party versus Jones. Jones was the Secretary of State of California. And they claimed that it was against a political party's freedom of association for outsiders to determine who would be their nominee. In other words, you can't just have people that the party did not permit to vote in their party primary to help determine who's their nominee is going to be. You can't force people to open up their doors of a private association or even a semi-public association to people that they don't want. This went all the way to the U.S. Supreme Court, and they struck down the California system, which was also the system used in Washington, as a violation of freedom of association because the parties could not control who gets to participate in choosing their nominees. But in a comment on that, Justice Anton Scalia of the Supreme Court, who wrote the decision here, said that it would have been okay if the primary had been nonpartisan. This is what Nebraska had that I mentioned earlier. So there is a case here that if you do this without party labels, then it would be okay to do something like this, that you'd end up with the top two system like Nebraska. He didn't say all that. I'm kind of explaining it. And then in 2003, this came up in Washington as well, Democratic Party of Washington State versus Reed. I think that was the Secretary of State there. Went to the district court, and then the court said that, yeah, based on that Supreme Court decision, Washington system was not okay either. And then it went to an appellate court that affirmed the district court's decision. So this earlier system where there's an open primary followed by each of the parties having to accept the candidate who got the most votes in their primary was struck down. So that one was out. And now folks who wanted to have some kind of open primary had to come up with something different. So now we got a new set of cases involved with this new system, which is the top two system that we have now. So in 2004, the state of Washington had the People's Choice Initiative, which is had the number 872, so it's sometimes referred to as I-872 for Initiative 872 of that year. And they instituted this top two system. All the candidates in the primary, top two go to the general election. And in 2008, this came all the way up to the U.S. Supreme Court in the Washington State Grange versus Washington State Republican Party et al. That means, and a number of others. They upheld the Washington system, said that top two does not violate freedom of association because they're not determining the nominees for each of the party. They're simply saying whoever got the most votes, they're going to the general election ballot. They could have a party label attached to their names, but that is not supposed to indicate that they are the party's preferred nominee. The parties have to make the case for whoever they want to be their candidate otherwise. So this was upheld by the Supreme Court. Now, Anton Scalia, who wrote that earlier decision, did dissent in this case. And he said that even though this does not violate freedom of association, it obviously violates freedom of expression because parties and candidates are excluded from the ballot, I presume. I don't know what his reasoning was there, but there was a problem with it in his eyes. And this is what's going to come up later, this ballot access problem. So the U.S. Supreme Court says top two is okay. And then in 2010, the state of California with Proposition 14, which the state legislature referred to the ballot, passed, and California adopted this top two system as well. So in 2012, there was a case in which it was taken to the federal courts to go back to the earlier Supreme Court decision and determine whether or not in practice this was actually working out as the U.S. Supreme Court expected. Essentially, the court found that the Washington top two system in practice has not confused voters as to the idea that the candidates who make it to the general election ballot with party labels attached to their name, voters did not confuse that with the idea that those were the party nominees. They knew they were the candidates who got the most votes in the primary, and they just happened to state the candidate's preference as one party or another. It wasn't the party's nominee. So they found that voters are not confused, so it's okay. And they also found that it does not harm minor parties, one of the other arguments raised, because the primary was late enough for those parties and candidates of those parties to have plenty of time to prepare to choose their candidates or to decide whether or not to run. And then the equal treatment of candidates was brought up, this ballot access issue. I think they said it wasn't a severe, the system was not a severe burden to minor parties, but I don't remember about the equal treatment part. That's something that's going to come up in a minute, though. I guess that's why I put that on the screen there. And then in 2015, there was a state lawsuit in California in the state court system, and both the district court and appellate court upheld the California top two system. This was Rubin versus Padilla. But there's been the case made in this new lawsuit that this decision had several errors in it. So they're bringing the case to federal court, not this case, but a new case, bringing it to federal court to challenge this top two system, even though the state courts had, up to the appellate level, had said that this may be okay. So what is this ballot access issue? Let me show you a passage from the Washington decision about the top two. And they said by giving minor party candidates access to the August primary rather than November election ballot, it was okay. Gave the parties plenty of time to file petitions for candidates and select their nominees, so on and so forth. So first of all, the I-872 primary is in August, not March, and that's good. Now, if it was in March, that would have been a different story. And in California, actually, the primary is in March in presidential election years and June in non-presidential election years. So March should be too early, and this particular decision would not apply to California. They also say that because candidates have an opportunity to appeal to voters at a time when election interest is near its peak and to respond to events in the election cycle, just like major party candidates, there's no discrimination against them. So the ballot access issue is not a big problem. All right, so now the question I'm going to pose here is, how are the federal courts likely to respond to this new lawsuit given those previous decisions? And what are the implications for changes in the California electoral system, and how would this affect other states in the future, particularly Washington state, but other states that try to adopt some kind of open primary system? I think they're likely to strike it down, primarily on the grounds that, as Anton Scalia said, it violates freedom of expression because voters do not have the chance to vote for a candidate of a party they support, and candidates of those parties do not have the realistic chance of getting on the general election ballot, at least a very slim chance of getting on the general election ballot. So that it violates freedom of expression, and also this issue about the early primary. Now, in the Washington case, which was lower federal court, they said it would be okay because it was in August, late enough in the process for minor party and independent candidates to get public interest going. But I think here in California, obviously, because it's too early in March, they're gonna say that's no good, and they may as well say that even in Washington, this is not acceptable because the primary election is not the same as the general election. The general election is the election in which the winner who gets the seat actually is chosen. So it's not just getting on the primary ballot, even as late as August. It's being able to get parties and candidates, give them some at least slim chance, not next to no chance of getting on the general election ballot, where they have a realistic chance of being voted for by voters and getting their membership to build and show progress from election to election, and presumably at some point maybe win a seat. So I think this part of it, the violation of freedom of expression and the the violation of the rights of minor party and independent candidates to get on the general election ballot is going to be a deciding factor. Now, this is a guess. This is speculation on my part from having read these earlier decisions and what they were based on. So I think this could mean that California and Washington as well are going to have to make some kind of changes to their electoral methods. And that would then have repercussions for movements in other states that are trying to get new initiatives to help independents to have some say on the outcome of elections, outcome of these primary elections, who gets on the general election ballot. All right, so it's going to have wider implications. And I think the Supreme Court is going to say, you have to fix this to the Washington and California states now. What are the likely outcomes, or what are the potential outcomes for ways that they could fix this? I've listed some of them here. Potential outcomes for the California elections. First of all, there is the possibility, and if you're looking at this on your screen in black, I give the potential option, and then in red, I raise a problem with that option. So first, they could revert to the electoral system that they had before they adopted Top 2. And that would be in California, and I think in Washington, to adopt or re-adopt a system in which you have party primaries and each party's nominee going to the general election. The problem I raise with this is that the public wants independent voters to have a say in the primaries and not be totally excluded, especially as the segment of the public, of the voting public, that's non-affiliated with any party has grown much faster in the last few decades than either major party. And in fact, those major parties have been shrinking because of this growth of non-affiliated voters. So there are so many independent voters that they do want to have a say in the primaries, and there's going to be political pressure to give them that. And in many other states, they do allow parties, major parties, to open up their primary to non-affiliated voters. But I don't know that that will be enough for those voters, because still the major parties could make a decision for any particular election to close again. So if the option is up to the major party, whether or not it's going to allow people who are not registered with that party to vote in the primary, it's not a it's going to put the power in the hands of the party, not in the hands of the independent voters. So I'm doubtful that they will choose that path, go all the way back to the previous system, especially with the public support for the open primary system as it is now. The second option would be to make the primary nonpartisan, as Anton Scalia in one of those decisions said it would be okay, like in Nebraska, if we had a nonpartisan election. But I think the parties wouldn't like that, the major parties in particular, but most all the parties really, because the voters wouldn't have party cues on the ballot for how to vote in the general election. That is, your candidates would get to the general election ballot and it would be just a name with no party cues. Now, a lot of independent voters might think that's fine. They'd rather choose it on the basis of the candidate rather than the party. But there's going to be other voters who are not as attentive to all the different candidates, and they want to know just, okay, I like the Democratic Party, who is the Democratic candidate? Or I like the Green Party, who is the Green Party candidate? Or Libertarian, or a Republican, or any other party. So I think voters, a lot of voters would be opposed to that, and the parties certainly would be opposed to that as well. There is a third option, which would be to move the primary later in the year, like Washington. Now, if the court does not strike down the Washington system because the primary is not the same as the general election, and it's the access to the ballot in the general election that's really at stake. If they don't make that determination, then California could move its primary later, but they don't want to do that because I think they do. They want to have an early say in the presidential primaries. As a lot of states start crowding earlier and earlier in the presidential primary calendar, California wants to be in on that. They want, because it's a huge state with a lot of electoral votes, they think they should have some say in which nominee gets a boost early in the process. They want to weigh in on that, not just wait until it's almost over like Washington and some other states do. you think they could move the presidential primary earlier and then have the other primaries later, but that entails other elections as well, more than one election. And it would be confusing because voters would have to go vote for president in one primary and then later on for all the other candidates. So if the court permits that, I think it would not go over well either. And I'm not sure at all that the courts would permit it anyway. And then a fourth option would be that you could adopt a top 4 or top 5 system using ranked choice voting in the general election. This would be similar to Alaska. And here, the minor parties can't complain that they are kept off the general election ballot if there's more candidates who actually get on the general election ballot. That is, it opens up the possibility, widens the possibility that independent and minor party candidates can actually make it to the general election ballot. I don't know that this electoral system has ever been assessed by the courts, especially the federal courts. I do know that ranked choice voting has been held to be constitutional numerous times, but whether or not this would pass muster as far as ballot access issues, I'm not sure. But even so, there is a problem with ranked choice voting in states larger than Alaska, as well as larger than Maine, which also uses ranked choice voting, although not with an open primary, that if you get into a larger state where they have to count voters over much larger territories and somehow bring ballots together, because ranked choice voting involves, determining first of all who got how many votes in the first round of counting, and then you eliminate someone before you can count the next round of counting. So even though it's computerized, you have to have all the ballots together, or at least find a computer software that can handle bringing all this information together. And it's a complicated system for choosing the final winner if you have more than a single round of counting. So I don't think this will be as attractive to these larger states if they look into how ranked choice voting might be implemented on a larger level. Now, there is ranked choice voting used in several local and county or city elections here in California, but it's a whole different thing when you go outside the scale of a county or a city to larger congressional districts, say, let alone statewide. So I think that will not be as attractive an option, even if it is held to be constitutional or to fix the ballot access problem. And then one final one, which I think is the most likely one, this would be number 5, adopt a different system used in some other states. There's a lot of variations of how to hold primary elections. And you could, for example, say that the voters do not register by party, but in the primary, they can choose which party they want to participate in. Because in most states, the way to join a party is actually to just register to vote with that party. This is the major parties in particular. So it's not like the major parties have some stringent criteria about who gets to be involved in their party and choose their nominees. All you got to do is register with the party in the state elections office. So it's not like it's hard. And you can simply say, well, let people choose which party on the day. We'll let them choose which party to affiliate on the day of the primary, or shortly before, when they let the state know which ballot they want, which party's ballot they want in the primary. So there are ways that you could fix this using a system in another state, and I do think that is the most likely thing to happen in this case. Which direction they go, if the courts do knock down this system, and then California and Washington have to choose different systems, as I said and have repeated probably ad nauseum by now, to the point of nausea, in case those of you don't remember your Latin. That's nauseating too for me to say, I think. It'll have implications for how states in the future decide to fix this problem of many independent voters wanting some say in the primary process. How are you going to do it? Now, I did want to mention, I had in an earlier episode mentioned my idea for a new political party, one whose primary purpose, not meant as a joke, as a pun, whose main purpose would be to offer an alternative to the major parties, but would be like an open primary in the sense that all the candidates who are not Democrats or Republicans could run for nomination or endorsement this new party. And then the party would use a voting method, star voting in particular is the one I have in mind, that would demonstrate a better voting process. So if we could get this going in California and demonstrate how well it works, maybe in the future, this would be, as states have to decide how to go forward, they would say, well, something like this might work using some kind of open primary system with a top five, but instead of using ranked choice voting, use star voting, which has a much simpler counting method. I'll go into that in future episodes, and I have gone into that in past episodes, but it's a scoring system rather than a ranking system, and the counting process is much easier, so it would be much more attractive to larger states in changing their electoral system. Other than that, my plans for doing this in California, it wouldn't change the date. Actually, any of these changes would make it easier because under the current system, I'd have to get something up and running to choose or endorse one of the candidates for the governor's race, which is the one I want to focus on, very early in the process. So if they have to end up moving the primary later or moving the big choice to the general election, then that means we have more time to get this new party idea up and running and to actually set a process in place and choose a candidate we want to endorse or to nominate. All right, then. So that's it for today. I will be back sometime this weekend to give you a catch up on the news, and then sometime either in that episode or in a near episode, an episode coming up in the near future, I'm going to go into this idea for a new political party more thoroughly. And I'm also going to combine it with what I'm calling a new party, which would be a party that would reflect my own views because, just full disclosure here, the reason I'm interested in this whole process is that my views are not well represented by any of the parties now in existence. But when I think about, okay, how do I promote my ideas to people? Well, in order to say, okay, here's some different ideas about how our political system should work and which policies we should enact and the rest of it, what can the people who join that party do about it if you end up just another minor party that's sidelined by our whole electoral process? So the thinking is, number one, we set up this new party that allows all these different minor parties and independent candidates and potential new parties to participate and try to get their candidates a top spot, and it can show where they're at in the scores, how far they've been able to get, how much they were preferred, even if they don't win the nomination or endorsement. So it's like how the electoral system should work. You have lots of different candidates representing lots of points of views, actually having some access to the people going to vote in that election, and then a process that shows clearly how the voters felt about each of those parties, and then which one the most voters had the most liking for. And so I think that's the way it should go. So then there would be an opportunity for my half a party with my own ideological positions and platform positions to have something to participate in, to have an action program where we could participate in this larger party, just like a lot of other parties and wannabe parties could. So if that wasn't all clear, I will clarify it in a upcoming video, and I hope you come back to listen to that. Once again, Political Dharma, Alan Zundel. Thanks for watching. I appreciate your comments. Please share with other people if you like the show and think they might be interested. Hit the like button and subscribe. And if you can, look into giving a donation. I've been meaning to put up some kind of meet the coffee thing, but haven't looked into it yet. In the meantime, you can give one-time donation if you go to politicaldharma.com, my website, where hardly anything is up because I've been I've been doing a lot of things and neglecting some things. This is a one-man show, folks. Or you can go to my Patreon account where you'll get these episodes a little earlier than they show up on YouTube and without commercials. And you can join for a small membership fee of like $2.50 to $5, something like that. And I would really appreciate any extra help I can get. So thanks again, and hope to talk soon. Bye.
I see the chains are breaking. We gained our focus. The moves we're making will prove to determine our self-worth as a passenger on this vehicle Earth.